Hey, Bill, when we last spoke, you were talking about your potential personal exposure or liability for mistakes made in the course of your business or for the debts of the business. When we're forming organizations to conduct business, we look at avoiding personal liability. The way to do that is to have an entity that would assume the liability and protect you from personal exposure. As we already discussed, operating as a partnership or as an individual makes you personally liable for damages claims or for business debts. The protection that is typically employed to avoid personal liability is incorporation or creating a limited liability company. An LLC and corporations provide a lot of benefits that you don't have if you're operating by yourself. Tell me, do you intend to have partners down the road?
Well, yes, that's quite likely. I expect to grow this business, and my feeling is that partners will feel more ownership in the business, and the business will survive and grow better if I give some ownership to others in this endeavor.
Well, and that can be solved by way of a partnership agreement, which is historically the way you do that if you're just dealing with other individuals. We can also do that in terms of a corporation or an LLC. Do you envision selling the business at any time in the future or passing it on to anybody else?
My kids aren't terribly interested in this particular field, so my suspicion would be that I would grow this business to a certain point and eventually sell it. That's right.
Well, you can do that as a sole proprietor and certainly as a partnership. However, sometimes it makes it easier to sell a business when it's a corporation because what you're really doing is selling the shares in the corporation rather than the individual assets belonging to the corporation. In other words, the corporation would own the assets and you would own the shares of the corporation, and the shares are what you'd sell. Corporations protect you from personal liability as long as you're paying attention to the rules. And you need to know these rules and you need to follow them. The rules include properly forming a corporation by filing articles of incorporation with the Secretary of State. You have to have bylaws and you have to have annual meetings of the shareholders and the board of directors. If you follow those rules, you'll be protected from any obligation you enter into in the name of the corporation. The law assumes that people doing business with a corporation are looking at the corporation for payment rather than to you individually. You could probably form a small closed corporation, meaning that it has fewer than 35 members and intended to be a small group which are not in the business for investment purposes. The way you can get in trouble with a corporation, especially a small closed corporation, is if you don't pay attention to the rules I just set forth. You have to have your meetings and you have to capture what happens at those meetings in your minutes. If you don't, you run the risk of being sued individually under the concept known as piercing the corporate veil. That means if a court decides that you're not acting as a corporation because you haven't paid attention to the rules, or it appears that you're just acting on your own behalf, the court can say you're not protected by the corporate shell. The court can also find that the corporation is merely an alter ego of you, and that you're personally liable for its debts. If we go the corporate route, you really need to remember to pay attention to all the rules.